all of you, and hope you had a good chat out there. So now we're going on with the artificial intellect, can't say it, the AI Act. So, and I leave the floor to Stefan. Stefan Larsson, he's Associate Professor in Technology and Social Change from Lund. And do you know where Lund is in Sweden? Yeah, the people from Denmark, they know.
Used to be part of Denmark, yes.
He's an old Danish man, and now my sound is out again.
They steal your voice all the time.
Yeah. Must be something with my voice. Yes, it's AI. Yeah, but I have just a quick one. So I leave the floor now to Stefan. Welcome, and you have to moderate all this panel. So welcome.
Thank you very much. Yeah, we'll try to crank up the energy a bit. It's a long day, abstract sort of concepts. And we also have, we're going to test the limits of hybridity at this panel. We have people in the room, we have people online, and we're also going to look at a video of a third person. So all of it at the same time, while also looking at sign language and possibilities of joining Zoom. So all modalities at the same time. My name is Stefan Larsson. I'm a social scientist looking at implications of new technologies. That's how I think of it. I run a research group at Lund University, southern Sweden, on the intersection between AI and society. So multiple issues on things like consumer rights or governance of AI or social robotics and interaction between human and technology, basically. I'm no expert in disability rights, so I'm, in that sense, humbly just here to learn. But I've been part in a study that the Swedish Equality Ombudsman is doing on discrimination or risks for discrimination with regards to AI. So they are doing it now, which is very good work. I'm happy to contribute to that. But it also includes discrimination, like already established law, and then you have to reinterpret that in light of AI, what it does, including disability rights. So that's one aspect. Already established law needs to be reinterpreted in face of sort of new technologies. But this panel is about, on the other hand, new law, which is being devised in light of what all of these technologies are doing. So we're going to talk particularly about the AI Act. We've been mentioning it a couple of times, but we haven't gone into so much specifics about it. We're going to do that more throughout the panel. First, I want to just mention a bit more detail on who's in the panel. We're going to talk to Maureen Piggot over here on site. Thank you. She's a part of the executive committee of the European Disability Forum. And we have online Francesca Fanucci. I'm looking at the camera over there, I guess, or here maybe. She's part of something called the European Center for Not-for-Profit Law, in short ECNL, replacing Karolina Iwanska, her colleague, who had to fell ill. And also, we're gonna have a video presentation from Brando Benifei, who is very centrally placed for the negotiations of the ongoing with the AI Act. He's a member of the European Parliament and rapporteur for the AI Act in the Parliamentary Committee on Internal Market and Consumer Protection, in short, the IMCO. So he's very much involved in it. So I'm gonna mention a little bit about the Act because Bruno's gonna talk about his work in it. Maureen's gonna come back to aspects of it. I can just mention that it was proposed in April 2021. Which means that the negotiations and the amendments has been going on for almost 2 years. And it's a very big thing. It's a sort of a complex piece of regulation that will have a great impact in how we think of how we regulate artificial intelligence. Parts of what's been sort of disputed or which has been debated a lot is the definition of AI. We have not really bothered with defining it today because it's such a flexible type of bag of technologies, basically, which of course is okay when you do research in AI, which has been done for at least since the 50s. Then when you have like a flexible area to test things, develop robots, or can machines learn, you collect data, find patterns in that. All of that is good if you're seeing it as a research sort of area. But when you shift that concept into law, then of course you need to specify it, because all of the stuff with law follows then, like the obligations, the rights. You can't enforce rights if you don't really know what you're talking about, and you can't put fees on whoever who's in breach of the law unless you define it. So then the definition becomes, central point for debate. And more specifically, this piece of regulation is highly leaning on ideas on risk. So from the 4 levels, which is debated in this regulation or placed in this regulation. Basically, the highest would be ban or the unacceptable risks. And then below that are the not banned, but sort of accepted under certain provisions, which will be high risk stuff. Very important category. Maureen will come back to that. And then you have the less risk and the acceptable risk. So very high stakes, low stakes approach to it. And then of course, much of the debate will be how you draw the lines between the risk levels, because that will make all the difference if whatever you develop will happen to end up in the high risk stuff or the non-high risk stuff, or in the banned, non-accepted. And just to stress it, this is also a work in progress, of course. It's not done yet. It's in the parliament debated now. So it means that we don't really know some of the exact definitions. We don't really know all of the sort of paths. That means that it can probably then, at the moment, it's still up for, it can be improved. I think that's it about the law. We're going to come back to it. So now we're going to move on to Brando Benifei, which would be the video. And I'm looking at my friends in the back to show the video on the screen.
Good morning, everybody. For those who do not know me, my name is Brando Benifei, member of the European Parliament since 2014, currently head of the Italian delegation in the S&D group and co-rapporteur for the AI Act in the IMCO committee, the Internal Market Committee. I'm also honored to be one of the vice presidents of the Disability Intergroup, working closely with the European Disability Forum. I'm well aware of the tremendous work of representation and advocacy that the EDF does on a daily basis. Therefore, please allow me to thank them for the invitation, as well as our guests today, the Swedish Disability Rights Federation. I apologize for not being able to participate in person to the conference. I will be traveling to the United States for a long mission exactly on the very same topic of the Artificial Intelligence Act. Indeed, we are approaching the final stages of the discussions about this big piece of European legislation. It should be finalized in the committee, with the committee vote in the end of April before going to the plenary vote. It has been an honor to work on such a fundamental draft regulation that has no other precedent in the world to look at. It has been a very intense experience that really felt like having a glance on the future. Each stakeholder involved is working with a responsible approach, which shows how much there is at stake for the society as a whole. During the past months, I was guided by the general, yet fundamental principle of guaranteeing and safeguarding fundamental rights of citizens, in particular, the most vulnerable ones. This ethical position is, for example, reflected in my fight to insert a fundamental rights impact assessment as a requirement for all deployers of high-risk AI systems before using artificial intelligence, and to make sure that public authorities publish the results in the database for each new deployment, for transparency, for the sake of the protection of our consumers and citizens. It is indeed fundamental to know whom a high-risk AI system is supposed to target and how, as the impact on people can be very diverse, and systems that are innocuous for some can be very discriminatory or severely impact other people, as you know much better than me. Is this action adequate? Can it have disproportionate impacts on specific groups of people? These are key questions that we have to keep in mind, in my opinion. As regards the rights of people with disabilities, although we had to adopt a approach towards the less inclusive political actors, we kept ambitious and determined. The UN CRPD is a clear reference that is in the text, as well as the right of most vulnerable people, the principle of universal design, and the consultation of representatives of affected persons, including people with disabilities. The fundamental right to accessibility has been preserved in the text that we are finalizing in these weeks, and I'm confident that we managed to control every possible attack to try to change and remove these principles with our amendments. Among requirements asked to the providers, we list accessibility in a formulation that covers adequately further technological developments well beyond existing rules from the well-known Accessibility Act. Furthermore, we insisted in guaranteeing further protection of rights of vulnerable people and children in the risk management system. In addition, the public database on high-risk AI systems will also have to comply with accessibility requirements in order to ensure equal access and transparency for all about the development and deployment of high-risk AI systems entering the EU market. Finally, while it was not possible to fully discipline medium and low-risk AI that we heavily rely on codes of conduct, the issue of redress is covered so to safeguard rights of users through several articles. Again, because high risk can be different for different people. The right to lodge a complaint or the right to a judicial remedy towards a national supervisory authority will be guaranteed. And we also inserted the AI Act into the scope of the Directive on Collective Redress and also on the Directive on Whistleblowers to increase the protections. I'm sorry for not being in the position to answer questions in person because of not being able to be there with you, but I look forward to continue our common work on the AI Act until it becomes law. The way to go is still long and we need to keep determined. Thanks to everybody for listening and for the willingness to cooperate on such an important topic. I wish you a fruitful discussion.
Well, thank you, Brando, I would say, right? It's a lot of things to unpack, but I just briefly, he mentioned the risk levels, links to other regulations like the Accessibility Act, the public database, which could store information about AI systems. So that would be some level of transparency ideas, and also the role of national supervisory authorities, which we don't exactly know yet, I guess. But we move over to our panelist, Francesca Fanucci, Senior Legal Advisor for the ECNL, the European Centre for Non-Profit Law. Could you please introduce yourself and tell us a bit more about the ECNL, and then particularly the question on your perspective, or what you think is at stake for people in general, and in particular for vulnerable groups in the AI Act. You can also comment on Brando's speech if something particular you want to bring up.
Yes, thank you for having me here, although only virtually. And my name is Francesca Fanucci. I work for the European Centre for Not-for-Profit Law that is based in The Hague, in the Netherlands, although I personally am based in London. And ECNL is an organization that works to strengthen regulatory and policy standards that enable civic space. And by civic space, we mean a space where all individuals can fully exercise their freedom of expression, freedom of association, freedom of peaceful assembly, and right to participation in decision making. So in this context, we are particularly interested in the impact that all these new and emerging technologies have on civic space. And we are keen, particularly attentive to ensure that the rights of vulnerable and groups and also minority groups are adequately protected. And it's a pity indeed that Mr. Benifei is not here in person. It would have been nice to engage in a fruitful, but I would like to acknowledge that when we started, when the AI Act was first proposed by the Commission, the slant of the Act was very much pro-market, market-based, internal market-based. So the primary purpose appeared to be harmonizing the rules in Europe about the design, development, even safety standards of these products in order to be more competitive with the other markets like the Chinese, the American one. So not to be left behind, not to lag behind, but also to improve, to foster innovation and research to improve the economy of the European Union, promote new jobs, new opportunities. There was very little reference to the need to protect fundamental rights of the people. And indeed, in the first iteration of the proposal, there wasn't even any mention of the need to conduct fundamental rights impact assessments. So this is indeed something that we advocated for and discussed constructively, even with Brando Benifei as rapporteur. At the time, he had been initially appointed as the only rapporteur, and then luckily it was acknowledged that freedom, fundamental rights were also equally important. So he was joined by another co-rapporteur of the LIBE committee, of the Fundamental Rights Committee. So little by little, we redressed the balance towards recognition that these technologies have to be compliant with fundamental rights. Another myth that we have been trying to bust, and we keep trying to bust, is that it's not enough that these technologies are ethically compliant. Ethics is good, but ethics is a set of principles that inspire our life, our beliefs, and obviously the way we also build products. But human rights entail specific obligations on states, as well as on developers and on users of this product. So ultimately, what is at stake here is that the rights of everyone, not just of the many, but literally of all people, are adequately considered, assessed, balanced when innovation takes place. We are no Luddite, we are not against, but we hear mantras like we don't need to stifle innovations. That's not our purpose as civil society. We want innovation to be human rights compliant, because that is the only way that it can be beneficial to everyone.
Thank you. I think you, a quick reflection, you put the finger on something that, that at least me as a governance researcher reading externally, that a struggle that's going on in sort of from the early strategies through the guidelines, often emphasizing ethics like you commented on, but this is like a duality struggle between pro-market innovation on the one hand and the other one, but it needs to be trustworthy, it needs to be secure, it needs to be, so that it seems to be like almost in agony sometimes, and I think you put the finger on that in a very nice way.
If I may quickly add, yes, I mean, it doesn't have to be a dichotomy. We're not saying that ethics should be left aside. Ethics, we change as society, our sensitivity change, so the ethics change, develop. Ethics informs the making of human rights, but ultimately these technologies have to respect what comes from rules, obligations, and other people's rights. And that's why we say sometimes we fear that ethics is used as first of all, because it is better understood by certain audiences. Human rights sounds very technical only for the activists, but ultimately we are talking about a reinforced mechanism. Ethics alone is not sufficient.
No, I agree. Some commenters say that it's easy to speak of ethics because it's like in principle, everyone would agree we should all be fair, but there's no hammer, there's no like exact detail in how to be fair. So as long as you keep on the general level without the hammer hanging, then it's easy to agree. So I completely, thank you for that clarification. We're going to come back to Francesca, but first move over to Maureen Piggot. Part of the executive committee of the EDF, but I think you also have some slides.
Yes, I'll introduce them as...
All right, so I guess the main question here, I mean, of course you can present your work with the EDF, but also what the impact of this proposed AI Act for persons with disabilities. So we move into even more specific than disabilities.
If I can take a slight diversion, are we working?
Sure. And you can also bring up things that we've heard.
Just a slight personal diversion on the subject and on my interest and the fact that I end up here on this platform. My interest in artificial intelligence started a long time ago. Personal interest, professional interest. In the 1990s, and another person in the room knows quite a lot about that, that's Ima Placentia. In 1993, the EU launched a research and development program, the TIDE pilot program, Technology for the Integration of Disabled and Elderly People. And I was one of the leaders of a project that looked at how could technology be used to support disabled people? How could we use the processing power, the ability to learn, machine learning, ability to learn from the user and with the user and to help the user to complete tasks that they wanted to complete. And we devised an integrated system that used sensors, environmental control, and very rudimentary decision support to prompt people through a daily living task, in this case, cooking, and cooking a very traditional Irish breakfast, in fact. We had a Nordic-Irish cooperation, and one of our partners was the Swedish Handicap Institute. So there's a feeling of a kind of circularity and being back in Stockholm and talking about AI all these many years later when we're in a very different place. What we learned from those early investigations was that the technology was unreliable and it didn't have the processing power that we needed, and that we didn't know enough about users' requirements, and that every bit as important as the technology that we were developing was the methodology and the ethics, the issues of consent and control. Who controls this technology? And have we got valid consent? Because the people we were working with people with intellectual disability, who in many cases were struggling with issues of calculating things, controlling temperature on a stove, managing the hazards that you find in a kitchen. So there were issues of control, consent, safety, and we learned that we knew very little and that there was a long way to go. Here we are, and now the technology is advancing so rapidly that we urgently need the regulations that we're talking about today. But we shouldn't lose sight of the potential benefits, and other speakers have said that here this afternoon. Persons with disabilities have perhaps even more to gain from the developments of these technologies in a rights-based and principled way than others. For the first time, we will have technology that can transform completely the person-machine interface to make technology accessible, available, and personalized. But that can only happen if it is driven by the desire to benefit people and not for profit, I think was something that Jared Quinn said in his report on AI. So anyway, getting back to the subject of the AI Act, we urgently need regulation. We urgently need this act to progress. And we've heard today that the parliamentary committees should make their determinations and their decisions on the outstanding issues at the end of this month. There's still a way to go to get the full Parliament vote. And then for the trialogue, the discussion with the Council, the Commission, and the Parliament. So still a way to go. And as we heard from Brando's update, some of the text has changed already from what we had when we were planning this conference. So we have a lot that we need to check in how that's progressing. If AI remains unregulated, we heard from the speakers in the previous session that the ignorance in the general developer and provider community about the rights, the experiences, and the circumstances of persons with disability will amplify inequality, exclusion, and discrimination. So we need to engage and we need to understand this topic, and we need to take that forward, as I say, with some urgency. So how is the EU approaching it, and how will that have an impact on persons with disabilities? As we've heard, the approach is a risk-based approach. I can have the first slide.
Oh, there is, good.
Oh, it's up there. I'm looking for it down below. There we go. So it's a risk-based approach, and that's the risk of harm to fundamental rights. So the risk that's being assessed is the harm to citizens' rights. And we've got 4 levels of risk: unacceptable, high, medium, and low. In the unacceptable risk, the EU has placed technologies, have also classified the technologies such as social scoring. So social scoring is where AI gathers data from everything on the internet, from use of smart devices, smart watches, from search engines, from databases, from your supermarket loyalty card, and from all of this information that's generally available on the internet, comes to a conclusion about the individual. And that conclusion might be that this person lives unhealthily, spends too much money on luxury goods, or buys alcohol, and makes judgments about those things. So that has been put by the EU into the unacceptable risk category. So social scoring has been banned completely in this system. You can imagine that such a system could be used to deny healthcare, to increase or deny life insurance, to deny credit, any number of risks attached to that. So we welcome the fact that that has been ruled as unacceptable. The technologies have also been classified into categories. If we move on to the next slide. And again, if you look at those, you can see the impacts that those might have and some of the specific impacts on people with disabilities. We heard earlier from the speakers about biometrics and how biometrics can be gathered from surveillance systems, the use of CCTV in public places, sorry, where was I going with that? Biometric identification of people. That is obviously a high risk. These are all the high risk categories, biometric identification of people. Applications of that we've been concerned about are in relation to migration. We know that at border posts, cameras are used, and sometimes cameras flown by drones that can identify individual people, and judgments can be made. So that is a high risk category. The live identification of people using biometric information is in the banned list, but European Disability Forum would like to see all of that biometric identification, live biometric identification, put into the banned category. Education is another high-risk area. In education, AI can be used for the selection of candidates for access to education, so access to third-level education or to any other level of education could be determined by AI, using data that is, as we know, very biased and unrepresentative. That can be decidedly exclusionary. AI could also be used for assessment of results, assessment of coursework, which has its dangers as well. Let me just get the picture in front of me so I don't have to look over my shoulder all the time. AI used for work, processing applications, as we heard both Jared and Yusha talking about, or also using emotional recognition and analysis of responses in live interviews, which has, again, discriminatory possible applications. Essential services and benefits. Migration and borders, we've already talked about. So you can see that the risks, these are high-risk categories in which people with disabilities face potential discriminatory uses of the technology. EDF proposes that in the categories that I've mentioned, the use of AI for those purposes should be banned rather than just regulated.
Thank you. Do you have I like that you bring forth this, what's the tricky part with this particular set of technologies is that they both can be empowering everyone, but they can also be used to control, surveil, and sort, you know? So that's the tricky part. We come back to that. I'm going to shift over to Francesca because I'm keen on, there is, I guess, a link over here because ECNL are also cooperating with other organizations and advocate for human rights. So I guess some of these things are part of what you advocate for. Could you elaborate on that particularly? I mean, you said some of it, bringing forth human rights, but give us more and elaborate on it a bit.
Sure. Yes, we are partners with EDRI, for instance, the European Digital Rights Alliance, and we coordinate our advocacy with partners there, which include the European Disability Forum as well. So we have ongoing discussions, and since the beginning, our advocacy position was focusing on ensuring that a uniform high standard of protection of human rights. So, as I said, this entails fighting for an obligation to conduct fundamental rights impact assessment, especially mandatorily before the deployment of one of these technologies, but also the possibility for these impact assessments to be triggered throughout the life cycle of the system if something occurs that triggers the necessity to review the system. Then we also, my colleague Maureen mentioned the unacceptable uses of AI, which are going to be banned. So we mentioned the live biometric identifications. In fact, we go maybe ambitiously, but a bit further than that. We also advocate for a ban on biometric identification, because there is this, we believe, this misconception that if identification is categorization, anything that requires biometric use is done live is more dangerous than if it's done post. In fact, it's not true at all, because all that happens is that the data recorded is retained, sometimes ad libitum, for potential further use unknown to the people who were recorded, because they may have known that on that particular day they were walking in the street, marching, protesting, and there were CCTVs with facial recognition technology, but The purpose at the time that they knew of was the public safety, the order of controlling the public. But if that information stays there for an unlimited amount of time, and maybe at the mercy, at the disposal, at the availability of other authorities, it could be reused for other purposes. And indeed, I have an example that I always like to quote, and I think it's particularly relevant in this context. In the UK, in the city of Manchester years ago, it turned up that material recorded from facial recognition CCTVs for protests had been shared by the police, had been passed on to the Department of Social Services, because they had requested to see this recording. They had had the brilliant brainwave to check if people claiming benefits for disabilities were taking part in those protests. And therefore, in their mind, if they were going to cheat on the system because they were supposed to be at home with disabilities rather than going to protest. As it turns out, there were cases. So they reviewed the cameras. They had their own watch list, their own data sets of people who, with pictures of people who had claimed benefits. They compared that with the images. They indeed identified some people that were there and they shouldn't have been, in their opinion. These people were called and sued and told that they were going to be deprived of benefits. As it turns out, some of these people on that day were simple passersby who were going to the pharmacy. So it was completely decontextualized. Having said that, the problem was that these technologies, once you have them, it's only too tempting to use them also for other purposes than those that are declared. So we have to be clear that as a minimum, the purpose and has to be very limited, but we go for full ban because also the technology, at least at the moment, as is proved by several studies, says that even if you have a 1% margin of error, we are talking about 1,000 people wrongly identified in 100,000. And there again, we go into the discussion, do we want to focus on quantitative criteria or on qualitative criteria? Why should the wrong identification of 1,000 people be less relevant or less damaging than the wrong identification of 1 million people? We're still talking about specific people whose life is going to be affected by that. So it's very tricky. But having said that, to complete the answering your questions, it's essential that all these assessments are also conducted with inclusive participation of civil society. It's only too good and fair to say, yes, you need to conduct an impact assessment. But how is this going to be conducted? And are the voices of the people, the rights holders, the people that are involved, going to be heard? So we also need to think of how to ensure that the relevant people that are going to be the recipients of these systems manifest their positions, their doubts, and follow closely also via access to data, transparency requirements to the development. We talk about trustworthiness, which is a term that instinctively sometimes we cringe about because, yes, trustworthiness is fine, but trust, when I trust something, I express an emotion, it's a perception. And perception, I may be a distrustful person by nature, so even if you present me with all the possible data, I will still not believe. Or I may be a very trustful person that wants to believe, but it's not enough to say it has to be trustworthy. Trust must be based on objective criteria of access to information, transparency, and inclusivity.
I think that's, you touched upon many major things, but one would be this participatory approach, right? We've been talking about that throughout the day, I think. So who is it for, and who is invited to be part of sort of that shaping of design or whatever tool? Just to mention on the seemingly little detail of, is it real-time identification or is it not real-time? That's part of the band category we saw on the top for those of you who doesn't follow the AI Act that much. And I like your argument that it's not necessarily very much an improvement that you remove the real time, because then you could, I mean, you argued in the sense that it may even sort of stimulate the recording and storage of potentially like sensitive stuff. So you sort of foster surveillance in a sense.
But Stefan, that's why EDF has argued for the complete ban of the use of
no exceptions.
Yes.
All right, good. Yeah, let's move on, come back to you, Maureen, because I was thinking also about the high risk category. And we haven't talked so much about that. The stuff that's not really banned, but could only be allowed to be used on the market under some circumstances. Could you expand on your work with that?
Biometrics in the Act is one of those things that's in the high risk rather than the banned category. But I think we've spoken about that sufficiently. But I think that Federica gave us an excellent example there of access to essential services and benefits and the risks associated with that. I wonder if we could just talk a little bit about what the obligations that the Act imposes on providers and users. So the providers can be either the developer or a seller of technology who incorporates that AI into their service or product. And the obligations that, because as we say, it's not just about ethics, it's about obligations. We've got to have concrete things we can demand to try to remove and reduce the risk associated with these technologies. So there's the public register. The providers have to register their technology. They have to have data quality and governance arrangements in place. Technical documentation that makes it clear how they have constructed the AI and how it should be used. Logs and traceability, and these need to be available for the lifespan of the product. Transparency on how to use the output. Jutta talked to us about algorithms really being statistics, and how we use statistics is important. This is the same with AI. It's how do we use the output of AI? If you remember the famous quote from, variously attributed to either Benjamin Disraeli or Mark Twain, lies, damned lies, and statistics, AI is in a new class of that for us. So users need to know how to use and interpret the output so that it makes it more valid. Human oversight, which is a very important aspect of controlling AI, and ensuring that the system is accurate, robust, and secure, again, throughout its lifespan. And something to think about in relation to these technologies is that they often change hands. It might be developed by one provider and bought by another. The obligations also fall on users. They also are obliged to take corrective action and to inform authorities when there is a problem identified with the system, and to cooperate with authorities in putting it right and in demonstrating that they are compliant with the regulations. So I just felt we hadn't talked about what we're asking,
right. You're right.
What kinds of protections we're putting in place with this act. And there's still a long way to go to actually secure even what has been put into the draft.
Not only changing hands, but also potentially retrained.
Yes.
So changing over time with multiple actors, which is making it more complex then. I think we should, let's go into like the timing now, the chronology, because now it's like the last phases. I'm shifting back to Francesca, because we talked about there will be only within 2 months vital sort of hearings or votes on it, and then the trilogue. So it's sort of within, it's a short time span left to do even impact anything. What would be the focus for the civil society movement then in the coming months, Francesca? This year, I guess, or the coming months? Pretty.
Oh yes, it's very timely because actually, according to the original schedule, there should have been a discussion now as we speak, end of March. Originally, they had hoped to reach an agreement at at least at the committee, joint committee level. But now we're talking about May, end of May, for the plenary to decide on the position of the European Parliament. And then, as you pointed out, there is going to be a trialogue, so tripartite negotiations between the Commission that originally made the proposal, the Council of the EU, so the different member states, and the Parliament rapporteurs. So at the moment, we are pushing hard for the position of the European Parliament to be as civil society friendly as possible, because originally, well, first, as I said, the first problem that we had with the original proposal was his extreme focus, absence of fundamental rights impact assessment. There were only conformity assessments. There were no obligations for such. There was this slant on protection of the market. Now, another problem that we're facing, and that luckily the Parliament seems to have sided with us on, is when the Council discussed the proposal and reached their general approach, they proposed a blanket exemption from the AI Act of all AI systems that are going to be designed or deployed or used for national security purposes. And the legal reason that they use is that indeed national security is one of the topics that is within the national sovereignty of the member states. It's not something that can be regulated by the EU. What they do not, I mean, it's a very convenient excuse, because as a matter of fact, the AI Act does not regulate the national security policies in which AI systems may or may not be used. The AI Act regulates the minimum characteristics that certain products must have in order to be safe, robust, trustworthy, and homogeneous in their standards in the market. So what we argue is that indeed, leaving aside the fact that a lot of these systems are dual use or even multi-use, we talk even about, there has been luckily also an addition to the AI Act of general purpose AI, which originally did not figure in the Act. So you have to imagine that a lot of these products can be swiftly repurposed or used in different contexts for different purposes. So ultimately, we want minimum common standards and safeguards for all of them, regardless of the sector in which they are used. That's why we strongly oppose, for instance, these national security exemptions. And so far, luckily, there were only a few voices in Parliament that supported this view of exemption. We are confident that this is not the final position that will be adopted by the Parliament. But then what we fear is that it might become a bargaining chip when it goes into trial negotiations. So, for instance, another thing that we strongly advocate for is a ban, inclusion in the prohibited, in the categories of prohibited AI of all AI systems for emotion recognitions. Because at the moment there is a focus on those systems used to manipulate, exploit the vulnerability of certain people in order to promise miraculous treatments, for instance. Whereas we advocate for a ban of these merely emotion recognition based products, because we believe that they are based on false assumptions that humans understand humans' expressions or emotions, therefore the machine can do it. We don't understand it either. It's ingrained in culture, it's ingrained in, well, I could become philosophical here, but nevertheless, this is another point that we want. We fear that there might be a trade-off. So something will be granted by the Council, but something will be lost. So that is where our campaign, aside from promoting the impact assessment, that's where our campaign is headed, to make sure that there are no loopholes that can be exploited to reintroduce from the window what has been officially kicked out of the door of the Act.
Thank you. I want to reserve some minutes for the audience questions, to think of a question and ask for it. I just want to comment on, those are no small issues. National security, but also general purpose AI. It seems like there are things that have been happening in the world, which is during the legislative process, that sort of put an emphasis on both of those questions. So you have war, so national security becomes more stressed, and then you have large language models, ChatGPT, which stresses the general purpose AI stuff. But I want to bring in the questions from the audience if we have. We have in the back. Please address if you want specific person to answer.
Thank you. Hello. My name is Shadi Abuzara. I work for Amazon. Thank you for the organizers. It's great to be here at this workshop today. Yeah, I am just wondering, the categories we're talking about here, work, employment, etc., are really, really big and have immense opportunities of assistive technologies here supporting people with disabilities. And I'm really wondering if ban is the useful answer. In the previous session, we heard a lot about ways, possibilities to add more transparency, to add more accountability, to put more protection. But complete bans, I think, to me, might not be the correct answer and might exclude certain uses. Just now, the talk about recognizing certain emotions, I think this is an opportunity to address certain kinds of disabilities that so far we've not been able to address with technology. So not allowing certain uses of the technology might, I think, be counterproductive.
Yeah, I think it's Maureen, right? Yeah.
Yes. Maybe I can clarify. I think I wasn't clear enough in what I was saying. It doesn't mean, EDF's position is not that AI cannot be used for anything at all to do with employment, but that AI should not be used to make the decision about the employment of someone with or without a disability. It can assist the process. AI can be used for handling large volumes of documents and for doing other parts of the process of recruitment, but not for making the decision. And similarly with the other areas, it's much more specific in terms, if I refer you to our EDF position paper, where you will see more clearly the kinds of applications that we want to see moved from the high-risk category to the unacceptable category. But there are some exceptions and all where we see the benefits of the additional processing or of the accessibility and other benefits that can come from using AI in those areas. But specific applications that are at high risk of causing discrimination are what we want to see put into the unacceptable category. And if I'm not answering that correctly, I'd ask for Kaveh or somebody else from EDF to add to it.
That was a good clarification, and we should check out the paper too. Good question too. We move on to a question over there.
Andreas Richter from the Swedish Post and Telecom Authority. I was part of a discussion concerning national EID in Sweden just a few days ago, and a lot of us meant that biometric identification is a possibility for many persons, because now we have to remember codes, etc., to be able to use an EID. And I think part of that discussion was that the alternative should be to use a code or using biometrics, etc. It was a while ago that like 20 years ago, I studied machine learning, but in my view, using biometrics for identification is a basic form of rule-based AI. So excluding biometrics completely hinders that.
Again,
what's your view on that?
I think I caused the problem by not being specific enough. It's using publicly obtained, like CCTV footage, where there is no warning about how the information, if biometrics are used, it needs to be clear at the outset that they're going to be used and how they're going to be used. But it's picking up indiscriminate, if you like, images and using that to identify people is what we think should be an unacceptable.
May I add, sorry.
Yeah, sure.
It's just that I believe that we also need to clarify that we are not banning biometric, we're not calling for biometric. As we all know, I mean, in the audience probably, but there is biometric verification, there are methods of biometric identifications, there are methods of biometric categorization. So if I travel with my ID and my biometric data are stored in my ID, and I go, for instance, to my passport, and I go to passport control, and what the machine does is take a picture of me at the moment and simply compare it with the data that is already stored in my passport. What they do is just verify that it's the same data. Fine, it's you, goodbye, that picture. My problem is what happens then to that picture that was taken, if it is stored, what's the privacy around it, the data protection, but that's another concern. We're talking about different levels of technologies used for with biometric, not all of which are AI, because they do not identify remotely or comparing images. So we are not being fundamentalist in that sense. We need to be aware what we are talking about. And also when it comes to emotion recognition mentioned before, we, again, it would have been ideal to have the intervention live of Mr. Benifei, because we are currently discussing whether the prohibition of emotion recognition that we advocate for should or should not include the caveat for medically proven and assisting technologies. We are not advocating, in case it is absolutely proved that somehow there is a medically sound reason, we can reconsider it. We are not of the opinion that this is the case now, because emotion recognition analyzes the state of minds, not the movements of people, for example, or to help them, assist them, for example, by opening their phone with the movement of the eye. We hear a lot of arguments from industry say you are going to this is going to block this. No, we are against those technologies that claim that they can read the people's state of minds and make assumptions, dangerous assumptions based on that. So once again, it's a very complex a topic with lots of nuances that we are very happy to consider.
It might, if I could just refer you to, there's a list in the EU Act, there's Annex 3, which is the list of high-risk categories, and it shows the category of the technology, which was the big blocks that we were talking about, but the specific cases that they are considering as high risk, specific uses that are regarded as high risk. And those are what we have focused on.
Well, thank you with those final words. I suspect the final words of in the triangle of AI, disabilities, and regulation is not, we're not done with this question yet, but I would like to thank you for the question, good questions, and thank Maureen Piggot for a presentation and good answers, and also Francesca Fanucci, thank you. Now it's time for a break. I guess we call it fika.